G'day everyone, and welcome to the fourth video for week 6 of our admin law course. As you already know, this week we're looking at grounds for review of administrative decisions. So far this week we've seen that a decision can be reviewed if it contains an error of law, if the decision maker fails to take into account all the relevant evidence, if they take into account irrelevant evidence, if there's no evidence for a fact relied on when making the decision, if they make the decision for an improper purpose, or if they make the decision in bad faith. In this video, we're going to look at a particular type of administrative decision called a discretionary decision, and two types of error that only affect discretionary decisions: making the decision at the behest of another person, or making the decision by making an inflexible application of policy. First, though, we'll need to talk about what we mean by a discretionary decision and how it differs from other administrative decisions. If you think about it, there are broadly two types of decision. The first type of decision creates a duty. It says if there is an application and the applicant meets the criteria, then the decision maker must approve the application. Can you see that in that situation, the decision maker's decision making is actually pretty limited? All they really need to do is decide whether the criteria are met. And if they are, well, the decision maker has a duty to approve. There's nothing more to decide. A simple real life example is the payment of a fee, let's say a car rego fee. If you pay the fee, your car gets registered. The person receiving the money only has to ask one question: have you paid? If you have, then you get your vehicle registered. The second type of decision is more broad. This type of decision creates a power, not a duty. It says if there is an application, and sometimes even if there isn't an application, and if all the criteria are met, the decision maker may make a decision, but they might not, or they might attach conditions. In this situation, the decision maker is more than just a cog in the machine. They're asked to do more than just check out whether the criteria are met. They're asked, in fact, to apply their knowledge, their experience, their discretion to make the decision. In a case called the Minister for Immigration and Conningham, the court made it clear that when the Parliament creates a discretionary power, the relevant public servants are entrusted with the capacity to make the decision. Let's apply this distinction to our driver logbook scenario. If the provision said, upon receiving a completed logbook, the chief executive must approve the logbook, then the decision would not be discretionary. All the chief executive would need to do is establish that it is a completed logbook, and if it is, they'd have no option but to approve it. In fact, though, the provision says after receiving the application, the chief executive must decide to either approve or not approve the logbook. The chief executive therefore has a discretion. He or she can receive an application and a completed logbook and yet still not approve it. When a public servant has this personal capacity to make decisions affecting the lives of other people, there are additional rules they have to follow. We've actually met one already. They have a duty not to make a discretionary decision in bad faith. The next one that I want to turn to is making a decision under direction. Section 5(2)(e) of the ADJR Act says that an exercise of a personal discretionary power at the direction or behest of another person is an improper use of power. If the Parliament gives a discretion to someone, then they're expected to actually exercise that discretion. They can't get out of exercising their discretion by just obeying the expectations of someone more senior to them. The example here is a case from 1970 called Bosanjak's Bus Service against the Commissioner for Motor Transport. The Commissioner in that case had the power to set bus routes in New South Wales and then to decide which bus operators were going to operate on each of those routes. Obviously, these were important powers because they would influence people's access to public transport and they would influence the business success of the bus companies. In this case, though, the Minister for Transport tried to reach down and direct that another company be appointed to operate on a particular route, and the Commissioner fell into line and appointed the company nominated by the Minister. Unsurprisingly, Bosanjaks were not happy about this. The law said the Commissioner was supposed to make that decision, not the Minister, and this mattered because the Minister is a political person who would be trying to win votes, while the Commissioner was a public servant who could make the decision based on what was best for the community. They challenged the decision and they won because the Commissioner was required to make a discretionary decision personally and not at the behest of some other person. The other rule I want to mention is found in Section 5(2)(f) of the ADJR Act, which says that an exercise of a discretionary power in accordance with a rule or policy without regard to the merits of the particular case is an improper use of power. This ground of appeal goes to the very heart of why we even bother having discretionary powers. The world is a complex place. The Parliament knows that no written law could ever be so comprehensive that it would take into account all of the potential circumstances in which a decision might need to be made. And so the Parliament takes the rules to a certain point. And then beyond that, the Parliament says, we're going to appoint someone to make actual decisions to fit these criteria to the million different situations which arise in the real world. That's why the Parliament establishes discretions. It completely defeats the purpose of establishing a discretion if the decision maker then simply makes up some further personal rules or policies and applies those inflexibly. When a decision is made discretionary, the Parliament wants an individual decision for an individual situation. Blanket rules are not allowed. The example I want you to look at is a case called Reed and the Vocational Registration Appeal Committee. Now, just through normal life, you'd be familiar with the Medicare system. General practitioners need to be registered for Medicare in order to realistically be able to practice in Australia. Without Medicare, doctors' appointments would be unaffordable. In this case, 15 general practitioners applied for Medicare registration. They were knocked back. The registration committee was concerned that these doctors did not have sufficient experience yet to be registered to practice as general practitioners. The committee was empowered by the legislation to make just these sorts of decisions. The thing is, the legislation didn't give the committee any guidance on how it should treat experience gained overseas, and so the committee had a general policy of ignoring overseas experience. These 15 doctors all had substantial overseas experience, and if that experience had been considered, there would have been no problem with their level of experience. Can you see where the committee fell into error? They were meant to make a decision based on all of the individual circumstances of each individual doctor. Their decision-making miscarried because instead of examining those individual circumstances, they simply applied a blanket rule. Now, before we leave discretionary decision-making, I want to circle back to the third video and revisit decisions made in bad faith. Can you see that if a decision is not a discretionary decision, bad faith is kind of irrelevant? If a decision maker is required to make a particular decision when the criteria is met, then provided they follow that duty, nobody needs to care whether they like it or not, whether they're in good faith or not. But the moment that a decision maker has a personal capacity to influence other people's lives, we expect them to exercise that decision-making power in good faith. Okay, now we have just one more video to go this week. So far this week, we've learned that decisions are invalid if they contain an error of law, if the decision maker ignores relevant evidence or considers irrelevant evidence, if there's no evidence of a key fact, if the decision maker uses a power for an improper purpose, or a discretionary decision-making power is exercised in good faith, in bad faith, or at the behest of another person, or inflexibly in accordance with a policy, and without considering the merits of the individual case. We've got one more video to go. In that final video, we're going to meet the last two grounds for review: Wednesbury unreasonableness and uncertainty. Hang in there, we're almost done.